Chang, I'll turn it over to you. Say welcome. Thanks for joining me on this adventure.
Yeah, thanks, Steve. Thanks so much for having me. I like to say that I'm a reformed lawyer or I'm a recovering lawyer, depending on my audience. But much like you, I turn to my legal education and experience often when I'm using AI. So this topic is really exciting. It's going to be a lot of fun. Um, it's a pleasure to be here. I know, Steve, that you talked a little bit about your background, but let me add, not only were you a lawyer, but you worked at one of the big firms here in town, McCarthy Tétrault. But then you became an in-house at Clio, which is like the legal tech company in North America, based out of Vancouver. And then you also co-founded AI in BC. You are the CEO of a software as a startup company, a SaaS company called Broadsight, and now the founder of Legal Now. So you've got legal and startup, software AI. You are going to be an interesting person to talk to, but I would love to jump right into it. So here's the thing. You used to be a lawyer. You've got a lot of education and experience with the law. Most of our founders and our advisors and our investors in the audience today, they don't have our legal background. So how do you think you use AI, especially when it comes to drafting documents or doing quote unquote legal work, differently than somebody who did not go to law school and who did not actually practice law?
Yeah, absolutely have the answer for that, but actually it ties in a pretty key thing I did want to kick off at the start as well, which is give a little disclaimer. It's really on point for that question, but this is
Okay,
disclaimer.
good.
This session is not legal advice. It's advice from technologists who have to be experienced working as lawyers. And if you're looking for comprehensive coverage and understanding of your full legal rights, your absolute best bet at that is to speak to a lawyer who has experience in a specific domain. So just for clarity, for everyone on the call, that's key. And by the way, one other quick shout out to Circle Innovation as a partner on this webinar. They're a BC-based nonprofit that helps tech companies get over barriers to growth. Circle provides upskilling, capacity building, and access to non-dilutive co-funding through programs like Fast for BC. They're excited to explore areas of innovation like this, which they can potentially share out with their network once they pick up on learnings from folks like us who are doing attempting to do some new things. So. But to your question, how do I use AI in a way that's different from folks who aren't trained lawyers? Really, it's the key thing is knowing what to ask, what to get out of the situation. So if I'm working with, one of our customers, one of our clients, in the process of, connecting them to a lawyer, a lot of what we're doing is scoping and kind of understanding their situation. So knowing what to ask, what's happening in the world, what facets of the business are important that have legal ramifications, and then getting really into once you can get all that out and you have it all on the table. And if I'm doing it for my own work, I sort of just have it in my mind. Then the key thing is to basically, structure the information. So, a big takeaway here for the session today is that LLMs work best in a complex field like law with a lot of structure on the, inputs. So it's, they say garbage in, garbage out. So if you're just sort of trying to one shot something, say, hey, produce me a shareholders agreement and you hands off and hope for the best, it's not going to get you there very well. It's going to be, every time it'll come back with 10, 10 terms, oddly, like, oh, that's interesting. Every project, yeah, GTP wants to give me 10 terms. Whereas if it's really laid out and you're, beginning to say, to the model, hey, what are the headings or areas of all this, the key things you would find in legal documents. Let's organize the information under those headings. That starts to kind of create this framework, which then LLMs are really excellent at filling in, but you need to, and they're good at sourcing issues as well, but often they miss things or they take a bit of a wrong tangent on this or that. So having that lawyer perspective enables you to really just orient around the right issues, catch the right all the issues that are most important and most high risk, and for that matter, avoid some of the ones that feel like they're high risk but actually aren't, because that's a little bit the lawyer intuition. And then once that information is well structured, it can go into creating prompts that produce strong outputs.
Yeah, that makes a lot of sense. While we're on the topic of using AI, briefly, let me take a quick excursion. So, in your poll question, you asked about which LLMs are people using. You
Hmm.
named a couple specifically, but there were a number that weren't on your list, and they'd be covered with the other category. But for the benefit of everybody here, which ones do you use currently and which ones do you not use? For example, do you play with DeepSeek sometimes, or are you worried about that? Do you use Gemini? Do you use Grok? What do you use, Steve?
Yeah, good question. And so a quick note on the audience first, actually, how audience is using these tools. Looks like Claude paid version is the head and shoulders kind of winner at 62% of people saying that, using Claude for some legal work, or legal oriented work, maybe we say, as many of the folks in the audience, I assume, are not lawyers. Then ChatGPT, also paid version, comes in next at 23%. Other than that, a quick note on, or a quick, we have one on Gemini and an unpaid for ChatGPT. So, Grok didn't feature prominently there. Myself, largely Claude and GBT. Early on in this process, there's a company we're working with a bit that had built a LLM tools, like 5 LLMs, all working at the same time, and they had actually one of the I think Chinese models plugged in there as well, which for some reason they found had fantastic understanding of BC law for whatever reason. So there are quirks out there to kind of be unpacked a bit, but yeah, I find Claude these days is incredibly powerful. And it's good to double check these sometimes, or just even reset the context window is useful too. There's a little tip. If you start working in one LLM and you get far down kind of these, offshoot areas or tangents or kind of deep into it, what's actually useful is almost reset the question, take it over to ChatGPT, saying, okay, well, here's what we've got so far. What do you see in this? Is there an error? What are we missing? That kind of thing. And if it's, resetting the context, you can get just a different vector into the problem.
Mhm. Yeah, great. Okay, so we've got a lot of founders in the room, in the virtual room, so to speak. And for many of our founders, it is essential for them to get in the minds of their user or their customer to really understand the people that they will be serving with their product or service. Now, that same approach can be taken when we turn it around, think about our service providers. So for our founders, our advisors, and our investors, they will be using and hiring lawyers. And it'd be useful for them to understand how the lawyers think in order to use the lawyer best as a tool. So
Mhm.
even with lawyers, you've got different practice areas, different levels of experience and expertise. As an ex-lawyer yourself, how do you think you use AI differently than, say, the typical real lawyer who all they do, 40 hours a week is lawyering work?
Hmm. Yeah, great question. So Legal Now is AI first from the ground up. And so, as these models are updating and evolving, we're, trying to stay on top of that experiment all the time to see what's the best outputs we can get from these. And in particular, we're building a bunch of process around this. It's not all just within the LLM, but there's a whole, framework of how we get information from users. And so law firms, particularly smaller firms, so many folks in the audience are going to be working in smaller firms because they have less overhead, so their hourly cost is going to be lower. Great to do, but at the same time, it's if you have a solo single practice, small practice, a lot of that time is actually just sort of busy, 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 keeping the lights on, attending to clients. And so the ability to stop and like redesign your whole sort of process with AI is challenging. There are absolutely some pro lawyers out there, like without question, and there's some folks posting on X and elsewhere that are like really, breaking ground with this stuff. So that's impressive. But we really are, aiming to keep up with the latest and greatest as well. And so how we're doing this, or that might be a little different than other lawyers, is understanding trying to take the chat history from your clients as well, not just
Mm,
the output. Oftentimes, and here's I think a key tip for folks in the audience, really this webinar is how you use AI, efficiently and safely. So certainly we'll get to some of the safety, but part of this aspect, the reason we're using AI is to make the work, legal work in general, efficient. So if you can come in to your lawyer with something that's actually, quite, helps them do their work better, then that's a win and saves time. What happens oftentimes today is that folks come in with a bunch of legal documents that Claude or GPT has created, sort of this big sort of stack of things, and landed on the lawyer's desk. And the lawyer doesn't necessarily know, okay, well, how did you get to these things? Like, how much of this is what they call boilerplate, just like standard legal ease that's in a contract, and how much of this is actually something you, as the user, a founder, were putting into this that was important about your business. So if we at Legal Now, aim to take the whole actually chat history, more important than the end output, to be honest. We've got sort of systems sort of like parse your chat history, or can send a prompt over to your LLM for founders who rely on LLMs a lot, and really know their business. We can ask the things we need to get out of it if it's got that kind of repository of knowledge or memory. and then we distill that into something that lawyers can go use. So that
Mm.
whole process has taken a fair bit of work to build, and so a small firm may not necessarily have the time, in most cases, just don't have the time to build anything like that, and so they're still spending cycles. A call is important to build trust with a client, but they shouldn't be on an hour and a half call asking a whole bunch of questions and billing for that.
Mm.
There's, in this day and age, don't need that. We can keep it more precise and focused, and then have a get to know you sort of trust building part of the equation.
Yeah. Yeah. One of the ideas that brings to mind for me is the idea that lawyers speak almost a different language. Like they've got their legalese, but they've got concepts where they even use the same English words that we use, like as non-lawyers, for example, but it means something very different. And
Yeah,
so oftentimes just trying to translate what the lawyer's saying, as well as trying to translate what we need and what we're trying to communicate, that can add hours, which is also billing for the lawyers. So
yeah.
that's something that founders and advisors and investors need to be wary of. But coming back to your use of AI, where do you trust AI to kind of fly solo on legal work versus where do you grab the keyboard back?
Fair, yeah. And so let's frame this as to how our audience here and potential founders, excuse me, what cases can they reasonably safely use AI? In what cases should they like pause for a second or stop or loop in a professional? And again, our goal in looping in the professional is to keep them, focused on key little bursts and points where they can, break points or gap points where they can like catch things. So there's a way to loop in the professional ideally, but certainly, a lot of legal work, you wouldn't just want to kind of one shot it and go out there with it and hope for the best. We can talk a bit more about the dangers, but back to the question, what can you use it for pretty confidently? One, just basic black and white legal questions like what's the minimum wage in British Columbia? It's fairly confident in that. Published law in this kind of similar realm. It's things that not only is it buried somewhere in legislation, a piece of law, but it's something that happens a lot in society, so that law firms have covered it, and there's lots of written articles, with some prominence and certainty on the online, which these LLMs can parse. So, for example, landlord-tenant law is very, well established. It happens so much. There's, millions of people are landlord and tenant. Whereas if you get into something really, esoteric or unusual or a brand new piece of law or, trying to anticipate where the law is going, then I would want a lawyer's viewpoint as opposed to simply the LLM. Other areas are translating legal concepts to plain language. So if users are getting a contract in, there's a bunch of legalese in it. LLMs are great at sort of like unpacking that, distilling that with a fair bit of confidence. If you keep them focused and there's, a document they're reviewing and not sort of looking wildly on the internet or hallucinating, it's going to do a pretty darn good job of, pulling things out of that, discrete piece of information you're sharing with it, a, 10, 20 page document, is
Mhm.
with confidence. And yeah, so summarizing information before you go into your lawyers, we've alluded to a bit, sort of like understanding your business world, whether that's having your LLM spit out a variety of useful information that's on point for lawyers, or just having it ask you questions. And then for creating first drafts of routine documents. So, for example, a sublease agreement, pretty straightforward. There's an existing lease that's there for whoever's leasing space. Oftentimes, startups are taking a smaller portion of a bigger tenant space. A first draft on that would be pretty straightforward if you ask the right questions. We can get a little bit to how do you manage your risk in this as well, but just kind of in this laundry list of one or two more things of areas where you can have relative comfort that at least the first draft and certainly the thinking and you know um, question asking and reviewing of documents is a fair bit of
Mm.
a fairly comfortable area. I'll say too that when you use a paid LLM, the output's a lot better and safer. So most of the folks who respond on the chat are using paid, so that $20 a month really makes a difference. And then, yeah, beyond that, I think, the other aspect that would just say around the paid ones is managing for data privacy. The unpaid versions can train on your data that you're putting in, I think by default oftentimes. So if you're concerned about, it's not that your information is going to instantly leak out to the internet, but if there's anything you feel proprietary about in what you're putting in, it's going to be a lot safer to do that in the case of a paid plan.
Mhm. Yeah, there's a lot to unpack there, Steve. I want to come back to that sublease example a little bit later, but first, let me touch on an area that comes to mind for me based on your initial answer. So when you talk about a sublease or you talk about landlord tenant, you and I know that this is an area of law that's different in every province and in every state in North America. So it's different in different legal jurisdictions, which
Hmm.
in North America is every province state. And then there are other areas of law where the jurisdiction is the country. So, if you talk about intellectual property, like copyright or patent law is Canada or the US, not province by province or state by state. So this is a distinction that you and I have, like, is part of how we've been trained. And so we know if it is criminal, then it's federal in Canada, but it's state by state in the US. If it's something related to employment, it is now province by province, state by state once again. The average layperson may not know the difference. And so they might not know what topic of law is now like a province based jurisdiction versus a country based, or maybe applies more broadly. And that makes me think it could be useful for many of our audience members here to have a checklist of items that they can refer to, at least until they start to learn some of the core words or concepts that they want to incorporate into their legal prompting eventually.
Hmm.
So one of these checklists or one of these checklist words might be jurisdiction, right? What jurisdiction am I in? Or make this jurisdiction specific as you answer this question, for example, right? Now, with that in mind, if we go back to landlord tenant and leases and subleases, like how do you know that it's jurisdiction correct? Especially if you're dealing with a startup company that is maybe renting a space in Toronto, even though the company is based in Vancouver.
You're saying how would we or how would the user on their
The
own
user
have
on their own.
comfort that
Yeah.
it is? Yeah, no, it's important to use documents that are relevant to your jurisdiction, as you raised for sure. And so, I think simply asking the LM to some extent, actually, here's how I would go about doing it is asking the LLM in the context of the place I am in this type of legal document, what are the top, 4 or 5 risks I should be concerned about? What are the key things at the top? So it's while there may be little small wrinkles around the law, broadly, you certainly want to tell a jurisdiction, and as a default, it should have a framing for that. But beyond that, it is, what are the, big sort of gotcha areas in this area of law, which, and often that'll make it sort of think or focus its attention to, yeah, what are the differences between this jurisdiction and that jurisdiction? What are the things that people often get wrong between them? So, a lot of this work is to kind of surface the things that are greatest risks for founders, rather than trying to turn them into lawyers themselves. Again, if you can afford it, you want to try and get a lawyer to check off all those last things and be comprehensive. But if you're working on a limited budget, which is the reality, a lot of what we try to do is get folks thinking of law in the framework of a risk spectrum, similar to insurance. Like, how much insurance do you want to buy for a situation? If you're driving your car, is it 1 million liability, 3 million, 5 million? What is it? Law is similar to that as well. In terms of, well, what the budget do I have, and if I get the key risks covered off, then there's some long tail things that potentially could happen. But as long as I'm paying attention to, not using LMs when there's tons of money involved or on some other kind of foundational things, which we can talk about in a bit. I got sort of a list also of areas where
Of course you
not safe. Yeah, I got lots of lists, lots of lists and lists. Um, and so, we can look at that. But anyway, it's just pulling it back. If you're focusing on the key most important things, you're like, okay, as long as I got those covered, then I decide how important are these kind of more long tail risks, or my layering. If I'm the analogy in buying insurance, am I getting the extra, clauses for, earthquakes or, internal plumbing errors, or problems of, floods, etc. So that's a little bit how we try to frame it for
Mm.
founders, so they're empowered a bit to understand it's not just right or wrong, or there's only one way to do things, which, to be frank, from my experience as lawyers, often sort of the training, there's just a best standard, but that's super expensive in a lot of cases. And if it's a small, like a sublease or something, and you've kind of covered off, big things like you're not taking on the responsibilities of the main tenant, you're not owning, their errors, and you've got your liabilities and waivers covers and those kinds of things, then it becomes a bit of a risk decision. Well, how granular do I need to go with this?
Yeah, I think you're right that it is a question of risk which is something that many founders don't think about directly in that way. I
Hmm.
like the analogy to insurance because it's practical in terms of understanding what a founder is dealing with when they're dealing with a legal question or issue. And it's also literal in that if you work with a lawyer, they have legal insurance. Whereas if you work with AI, you do not have legal insurance covering the answer. Now, I want to
Yeah.
touch on that a little bit, but before I do, let me point out that this is a Zoom webinar. So we have the ability to chat. And if you want to chat, the chat will be seen by Steve and I as the hosts for you. We also have a Q&A function. So if you click the Q&A function, you can post your questions and we will answer the questions live here in our conversation rather than answering them in the typed out format. And a couple of questions have already come in. They're really great, so we're going to get to them as well. And I want to come back to this idea that it's about risk. Now, when I think about risk as a founder, I know that I'm taking the risk. When you
Hmm.
pay a lawyer, your lawyer is not taking the risk. But oftentimes we have founders who maybe have less experience in business in general, or they're early in their startup. So they pose questions to their lawyer and they're looking for an answer, but their lawyer takes zero risk. And so we call it the business decision. The founder is the one taking 100% of the risk and therefore needs to take the responsibility of accepting both the liability and the benefit of that decision. And that's what risk is all about, right? And so when we think about risk, what is the best way to approach using AI for drafting legal contracts and doing legal work from a risk or risk mitigation perspective?
What's the best way to do it in terms of
Yeah.
you know, process folks would use from the perspective of risk? I'm definitely, well, firstly, it's understanding, what areas are of greatest risk, and I'll go through that little, as I alluded to, laundry list now, or in a second. But yeah, I think you want to understand if you're in a danger area, then you just need to know that and apply a greater, higher vigilance level yourself as the founder. But then once you know that realm you're in, again, I would bring it back to asking, what are the main things I should be thinking about, kind of focusing in. But here, why don't I just talk you through areas, firstly, of more danger, of more risk. That would be foundational documents. So
Mm.
think like shareholders agreement or IP documents. So, these are often things that when everything's going swimmingly, it feels pretty easy and straightforward. You're getting along with your co-founders or whatnot. Everything's fine. There's not much money on the table, but years down the line, there is money on the table, and maybe there's a disagreement going this way or that way, or something's changed in relationship. So pay a lot of attention to those when everything sort of, seems hunky-dory, but, with something that's so foundational that it could, rupture the foundation of the company, which I've seen multiple times in the past. Intellectual property as well is one where you're going along building things and everything seems fine until there's a problem, right? Until it's not. And so I think IP is really crucial to get right if you think of a situation of a developer or someone who's come in from another company to join your company, but then they start using confidential information, trade secrets of the former company. You really need to, on one hand, create contracts to avoid that, but on the other hand, have some policy and process around talking to that person, understanding making sure they know where the lines may be in that area. Other foundational areas would be emotional, those that are emotional. So oftentimes in employment, we take our employment obviously quite personally. And when things go sideways, if someone's not a fit for the company, often, the company may feel they need to lay someone off, or that person may not take too well to that. And so there is a lot of protections actually in law for the employees because there's sort of this perceived imbalance between employer and employee. And so there's a lot of like, in a way, power that employees can assert. And if they're not feeling happy about the situation, they may be quite irrational about it. So look for areas where, law can help you guard against irrationality or, highly emotional situations. Certainly the employment side of things is key. One or two others, where there's a lot of money at the table. So investors come in with certain, provisions. I heard of one thing just about 2 weeks ago where, one investor early on had put some form of liquidity preference in the fundraising documents, and that got copied in future rounds. And so the founders didn't really fully understand the implications of this. It's like when the math on the first one got compounded by the next one, it almost grew exponentially. So by the time it mattered, they're trying to raise a big round. They suddenly realized they had 40% more liquidity preference to cover, like meaning you have to get over a hurdle of a certain amount of money back out of the company before the main, underlying investors get paid, or the underlying founders and early investors get paid. So it's just basically, all but killed the deal. I think it took them 6 extra months to try and raise money because they just didn't understand. So these kinds of things, at the outset are absolutely key. Other quick areas where there's overlapping legal regimes, cross-border issues, tax and corporate often overlap, but for, hard to predict reasons. Yeah, and then other kind of danger areas. The last one I would just say is case law. You know, LMs are kind of famous for finding case law, but then hallucinating others as well in that process. And folks going to court, lawyers do even without the right precedent, or without the right reference. So double check those if you have any situation. And it's certainly, I would say, dangerous to try to go to court without a lawyer at all involved, but people do it. You kind of want to just double check those references are correct because judges hate it when you come in with something that's completely made up. So let's try and avoid that. So yeah, that's to answer the question. Really, main thing is like, where am I in these danger areas? When should I really rely more on a lawyer there versus knowing, something that's low risk? Yeah, what's minimum wage for BC? This is a comfort area. And then how you create that framework is asking the LLM or asking the professionals, what things am I most concerned about? Asking even your advisors, board members, not that AI or lawyers need to have all the answers.
Yeah, that's a great point. With the liquidation preference example, uh, that's a tricky one because I know that many, maybe most Series A investment documents will include a liquidation preference of some sort. And in
Hmm.
the later rounds, Series B and beyond, it's going to be absolutely required. You can't get away from it. But when you're first taking in your first 25,000, $50,000 from your uncle, or if you're doing like a very early pre-seed angel round, that's where liquidation preference is a little unusual and often not present. And so
Hmm.
knowing when it's appropriate and how to structure it is often more important than simply black and white, it should or should not exist in your fundraising documents. So with that in mind, let's go to some of the questions. Some of the questions are really great and they get more specific. The first question is from Hamid. Hamid asks, are they, as in AI, are they reliable enough for drafting documents like NDAs, like non-disclosure agreements, contractor or employment agreements, and things like that for a business? Steve, you and I have talked about this before. When we think about NDAs, we like to consider this more of a simple document, right? Because it's one of the most common documents used by early stage companies. And it can be quite simple. I've told you that I've got like several different template versions depending on the situation. I've got a one-page NDA template, a two-page NDA template, a five-page template, a seven-page template, and a 12-page template. And they're all very, very different, right?
Yeah.
And then for every NDA template, I would adjust it for the jurisdiction. If it's international, I make other changes. So this is how I approach this simple document. Of course, most of our audience is going to be using AI to create or customize their own NDA. And they're not like a large company where they can have a lawyer do that work for them. So how do you think about NDAs? Do they cover all the issues? How does a founder or an advisor figure out if an NDA template or a document from AI is missing an important cog that will turn the startup's wheels? Like,
Yeah.
how would you approach this question?
Yeah, no, it's a key question. The NDAs, where we started this business, Legal Now, was like, okay, how do we solve for NDAs and go from there? Because it's just that thing that, basically every business needs at some point, or early on. And yeah, my thoughts around that are really the use case. And you really touched on it there, Chang, of like having different levels of depth, because the reason for that is because you're assessing different use cases, like pulling the right tool out of your toolkit when something comes up. So I would say if you are dealing with, deep intellectual property, you're doing some sort of really involved partnership. Someone's going to manufacture, something that you've, custom built that either has trade secrets embedded in it. You're working on a patent, the patent's not public yet. All these types of things. That's a high danger area. Again, I'm going to try to use this sort of spectrum of things and let the founders try and make their decisions along the way. Because certainly best practice is like always see a lawyer to make sure everything's covered. But if you can't afford that, then it's like, okay, let's revert back to this risk spectrum. So what I described there with like deep IP, that's where I feel much less comfortable just relying on AI because it's going to miss things about your factual situation. You as a lay user may not be able to elicit all the right questions from what you're doing in your business to get there. But on the other end of the spectrum, what I think was like this cog in the wheel, like an NDA can help business parties just kind of go and have a meaningful conversation, even if it's not covering off every last sort of like little risk. But so many often those conversations aren't going to turn into litigation down the line. I mean, there's always the risk, admittedly, but so often, the cost of litigating an NDA would be, that tens of thousands of dollars. What is that initial conversation going to work out to? Like what's discussed in that? It could be, I guess, months long, a relationship with a business partner, but and the deeper in you get, I guess you could reassess. But at the outset, it is often just, hey, we need something in place to move this ahead. Let's put that cog in place so that the wheels can turn and we can, conduct
Mm.
business. The cost of that versus the cost of the really involved 12-page, version that you have. And the last thing I'll say about NDAs actually is, funnily enough, it's the one document that there is a source of like really good standard form out there on the internet called One NDA. So if you just Google One NDA, it's like a really good, very open platform, covers a lot of things off, and it's very adaptable to what you need as a layperson. It's kind of designed that way. So much of what founders do and lawyers do is using AI and tools for now, but that's actually an area where someone has gone to think as clearly as they can about the best form in the world that I've had a ton of lawyers weigh in on it. So one NDA is a little tip.
That's a great tip. I'll offer a couple other comments and tips as well.
Yeah.
So for some of our earlier stage founders, they're going to meet investors that will refuse to sign an NDA. And that's because some investors see like 10, 20, 50 potential companies to invest in each week. So if they signed an NDA for every one of those, they wouldn't be able to talk about anything ever. And so as a practical matter, it makes no sense for some. With that in mind, though, there are certain kinds of maybe proprietary or trade secret type secret sauce that you have where it's going to be very dangerous to talk to anybody about the details of what your tech actually does without an NDA. So there's no one right answer, but you have to do a balancing. What's the best time to require or offer an NDA? When's it not appropriate? And then when you do offer the NDA, we use the word NDA or we use that label quite broadly. And while NDA is an acronym for non-disclosure agreement, it can also often wrap in other aspects. Like it can include a non-compete agreement, or it can include a non-circumvention agreement. So we use the term NDA quite broadly, but the specifics matter. And as a general rule, it's going to be useful for audience to understand. If your NDA or your non-compete or your non-circumvention, if it's broad, like it covers all AI, probably not enforceable. If it's very specific to what you do, the more specific and detailed it is, the more likely it is legally enforceable. So you need to ask yourself, is this something that I'm trying to actually pay, litigate, and enforce? Or is this a check the box so I can be seen as covering my bases as I'm building my startup? And so that's one way to think about the NDA. I think the other thing is there are many jurisdictions where the idea of an NDA and the related concepts, non-circumvention and non-compete, these will simply be non-enforceable entirely if it's seen as an employee-employer context. That
Mhm.
includes contractors. So for example, Ontario is harsh about this. If in Ontario you've got a contractor and they're your web developer or they're your back-end developer, and even if they're a contractor, if you make them sign an NDA or non-compete, it's probably not going to hold up in court because Ontario doesn't want to have people not be able to practice their livelihood because of some sort of contract. So with that in mind, and BC is not as harsh as Ontario, but there are restrictions around employment-based NDA documents in BC. With that in mind, documents can be different in different jurisdictions. So we'll pause there on the NDA. It can go a lot deeper. We're going to go to the next question, which is quite a shift in topic, but it's a really interesting question as well. This is from Jeremy. Jeremy asks, well, what about marketing and client development? Is it better to try to set guardrails based on local advertising rules or simply review these rules as a guide in mind? What do you think about that?
Yeah, no, interesting question for sure. Um, So a little bit back in my mind, this is a little bit back to the structured data side of things, where if you are operating around where you know what the rules are, and now chatbots can help you find those, then creating a project where it's kind of embedded, it's kind of the rule set that it always acts on is certainly going to tune it up a little bit. So tweak it and have it understand where is it operating. A good, just by the way, prompt for folks is giving the AI a role to be a lawyer, like let it know it's understanding, its context outputs will be, a little bit more on point when it's not just, general questions about the law, but actually lawyerly outputs. Um, that's another thing to put in. And so, I think just kind of embedding that rule set is going to help. But interestingly, like to my mind, advertising marketing rules is one where it's not as always set locally. I mean, there are consumer protection acts that vary a bit province by province. But Chang, I'm actually curious your perspective. If you've seen this come up with companies where they're triggering something that's off in one province versus another that is really kind of localized there, or U.S. versus Canada, there's going to be bigger differences there. So yeah, any impressions you have on that one?
Yeah, absolutely. So when it comes to the idea of advertising rules and laws and client management development, I would say it's usually country by country and not province by province or state by state. So there's advertising laws that apply generally. Think about what's on your website, think about what's on your packaging. It's a physical product. And then these laws often overlap with copyright law as well. We're also going to be touching on laws that relate to communication and privacy. So the anti-spam laws are national. Privacy rules, there are certain provincial ones, but the main ones are usually federal.
Hmm.
And the exception there would be GDPR in Europe. And then California has its own privacy rules that are more stringent than almost anywhere else in North America. So if you meet California's privacy rules, you'll meet everywhere else in North America in terms of practicality. And so those are some of the areas to touch on when it comes to advertising and communication and privacy. Uh, let's go on. Before we go to the next question, though, quick logistical comment. So one of our attendees has noted that the chat is disabled. Um, I think the chat is possible, but it's only viewable by us if somebody puts in the chat. Maybe you can check on that, Steve, and I will treat that comment as being an answered question. As you check on that, our next question is from somebody who's anonymous. Uh, Mr. and Mrs. Anonymous says that they find AI generates very lengthy documents. So when's it appropriate to have a lengthy document that maybe covers every possible scenario versus when's it better to have like a shorter, streamlined document?
Yeah, definitely thoughts on this. Oh, and by the way, I enabled the chat, so I believe you can chat to us now. So there's yeah, and other panelists it looks like. So there you go. Um, I will say then that on this one, yeah, sorry, just remind me which question was the one where, oh yeah, the overlap between the
Lengthy
length of
documents versus
Thanks,
short
Bob.
documents.
Yes, exactly. So I would say this is a real business question as much as legal because you are trying to, with startup, you are trying to accomplish a goal, often with parties much bigger than yourself. So we had this experience with one of my startups where a lawyer had gone and created quite an extensive, super long SaaS agreement, just standard agreement to purchase SaaS services. It was like 25 pages long. And oftentimes we go to clients and they would be like, these big enterprise clients, we're small startups selling to big companies. Their lawyers would be saying, "This is this overwieldy, like, and just one of the heaviest documents I've seen," and it keeps getting pushed to the back of the list on their desk, and it would just take forever to get these things through. So I came along, realized the problem, got in there and cleaned up a document that was 9 pages with a better template to begin with, just quicker, faster. Still covered off. I don't know, probably 95% of the same risk that the bigger one did, but it just got it through way faster. Deals started closing faster because lawyers, saw this. They're familiar with some of this, the way it was written, and we're happy that it wasn't too long, and so it just kind of was more deal friendly. So I think there's that kind of judgment call for the founder of like, do we need the super long one or not? And it's a bit case by case. If it's a routine thing you're doing, day in and day out, you have comfort around those issues a bit. If it's a one-off thing with a really complex patent, licensing scenario, maybe it's got to
Mhm.
be pretty long. I kind of picture in a perfect world in a way, and this is maybe in the future, but it'd be interesting if legal documents were 100 pages long and no human fully read them. Like, you just put in your inputs as a human. Here's what I want. AI produces something incredibly long and extensive and covers off every risk. That goes to the AI on the other side, parses that, pulls out of it the key sort of things, and the lawyer reviews and says, "Oh yeah, my checklists were good." And embedded in that is every last sort of thing. So anyway, it's a bit of a future casting. Hey, where might this all go? But today it's that founder call, and a lawyer can even just help on that. And that's a quick, short conversation, frankly, with the lawyer is like, we've got this big, long document. Like, how should we think about this? This is an area where we can, parse it down a bit. And AIs can be great tools in that, where you can say, hey, we got this something long, cut it in half, and it'll literally just like try and make some decisions. I would prompt it more in a more complex way than simply cut it in half. But conceptually, it can do that.
Mm. So you use AI to create a document, you send it to somebody, that somebody, the counterparty, they use AI to review the document, suggest changes. It's really just AI negotiating with AI.
Yeah.
And pretty soon they'll cut out the humans in the middle because the agents don't need the humans. I'm doing this already because with my Claude, I've connected it with my Google Calendar, my Gmail. It reviews documents and emails itself, and then it'll respond itself. I do want to read it and check it, but I've already taken myself out of the loop because human in the loop actually slows it down in time, like in certain cases. But having said that,
But
if the question is, should you use long documents with AI or should you use shorter documents? My answer is yes, because when I was working for an international bank, we would have licensing agreements, and if these licensing agreements were under 200 pages, they were missing something. Like,
oh,
so a document in this context of an international bank licensing technology for international businesses under 200 pages, it's too short. And I have created an NDA document. It's one paragraph long. It's not even a document that you attach to your email. It's in your email body. I
mhm.
email this to somebody and say, hey, this is my non-disclosure agreement in the body of this email. Read it, copy it, paste it in your reply, and type your name in and say, I agree to these details, to the terms and conditions of the NDA.
Yeah.
And that's like a one paragraph NDA sent
Yeah.
and received by email. And that is sufficient to say, hey, I've got a written NDA document signed.
Yeah. I love that.
Is
That's
that
sharp for
true?
sure. Yeah.
Right? So
Yeah. It's
so
case
that's
by
the right
case.
answer. It depends on the context for sure.
Yes. 100%
Yeah.
agreed on that.
Yeah.
Yeah.
We're getting a lot of questions. We're already at 11:17, so we only have 13 minutes left. I know we could talk for hours about this stuff.
Yeah.
Let's try to scream through these questions and get each one answered because the questions are really driving our conversation and they cover every topic that we want to talk about anyway. All right, the next question is from Sandeep. He says, "What do you think about the idea of generating legal documents using AI and then having those reviewed by a lawyer? Is that more cost effective or could that even be more expensive?"
hmm Yeah. Key question. And that one also depends a bit, um, because it depends a bit on the lawyer's process, I would say. So I work with some firms that are really sharp on AI themselves. So certainly this is what we do, as I alluded to a little earlier, of like trying to parse information, trying to get the chat history of folks. So like using AI to, create a document is actually quite useful for the founder to go through the question asking process and like reading it through and thinking things through so that when you come into the lawyer and have the conversation, you're better informed. So I say on the whole, good to start and get that work going with the LLM. You may miss some things and may actually, to be honest, steer you a bit astray, but it's the lawyer's job, if they're good, to come back and bring you back to the main, focus,
Mm,
and the path you want to be on. And then if they are an AI powered firm themselves, they can often, take a lot of the context from that conversation. We use transcripts, for example, with lawyers. So we'll take that information that's discussed, take the onboarding documents, take the contract you come in with and try and say, okay, well, what's different about this relative to just a full-on boilerplate, completely standard document, to try and parse and figure out what the things were in there yourself. And so if you're working sophisticated with these tools, it helps. It's faster, it's more efficient to answer it. However, a law firm that isn't necessarily up the curve with these, time-saving devices, they're going to be a bit frustrated in a way, and sort of feel like there's a sense of lawyers like, oh, clients come in trying to think they know all the answers. They got their thing from the ChatGPT, and then like, what good am I doing here? There's just a little bit of that reticence, kind of pushback. And so, if you're getting that vibe from a lawyer, maybe that's not if you're a very AI first founder, maybe that's not the right fit for you lawyer wise because they're gonna, ask you questions, sort of almost restart the process or like, spend a lot of time trying to read personally one on one through all these documents. Whereas, back to that structured data, if we can pull out of this massive information, the things that really matter and focus the lawyer's attention there, that's what we do at Legal Now. And smart lawyers are doing the same thing, but other folks are working in a bit more of a traditional way that's not necessarily going to keep up.
Okay. Yeah, this question actually ties in with the next question and one of the next questions after that. So let me ask those questions as well, and then we'll answer them kind of as a bundle. The next question is by Sarush. Sarush says that he uses AI primarily for finding FTO, that's freedom to operate in the IP space, and
Mm-hmm.
doing intellectual property searches. He thought that would be great for AI for legal, but Claude warned him that once he has the search analysis or conclusions from AI, that they should give it to a lawyer so that the lawyer can take responsibility, especially if they have actually infringed on somebody's IP. And
Mm-hmm.
so Suresh wants to know, is that true? Like if the lawyer does the IP search or the FTO search, then does now Suresh have somebody else taking responsibility? So
Mm-hmm.
that's Suresh's question related to what we're talking about. And then Sajad has a question that also ties into this. Not obviously for most people, perhaps, but for us, for you and I, we see the obvious tie-in. The question is, how does lawyers' insurance benefits and coverage work? Do all lawyers have insurance? So, so the question is, you use AI. Does that make lawyers spend more time or less time? And the short answer is it depends.
Mm-hmm.
Some lawyers have to go through everything that you've given them, review it, and then go do their independent research and search because their name is on the line. They will be responsible and liable for what they tell you. So sometimes it can cost you more by giving your lawyer a long result from your AI. That's possible. If you use your AI to parse the information, learn the law, figure out, how long is a statute of limitations, and then you incorporate that into your question to the lawyer, you can actually save a lot of time, right? So it
Mm-hmm.
depends on how you use it, I think. What do you think about this idea of taking something from AI, giving it to a lawyer so the lawyer is responsible?
Yes, I love that, to be honest, because it's the lawyer's job to know what they need to be, what information they need to be able to answer the thing correctly. And so, if there's a lot of information that the AI has produced and it's reliable, then that's helping them do their job. And they have a further job to say, okay, you give me 80% of it, but we got to go search for this 20%. And so, I do want to touch on the idea of a kind of an IP search or freedom to operate. Where I would trust AI most is when you have a box where you know the answers are within that box. So if you had a contract, you want to know what it says, you bring it in, it focuses, it gives you the answer. Where I'm less confident in it is saying go and find all these things on the internet to make sure I haven't missed something. Because AI may miss things and not tell you that it missed things, whereas a lawyer knows how to use the tools that are available, traditional tools and some AI powered ones, to make sure they do the appropriate professional standard of not missing something. And so there are, that is a case where then you can rely more on the lawyer than the LLM, because again, there's an established way of doing this. And they do have insurance. So to kind of rounding it out with that question and how they link together, Chang, it's, the lawyer is willing to, take some risk. Well, in a way, it's, as you alluded to earlier in the talk, it's, you know, lesser risk because they are themselves insured. So every lawyer is insured by the Law Society, Bar Association, etc. They pay insurance, fees every year, and that, in theory, if they do something quite wrong and it results actually in malpractice, then you, the client, have the right to claim from them, and they can claim from their insurer and sort of try and get things covered out. It's not always easy. It may be a lawsuit that's not cut and dry in a way, but it gives you more comfort that the same thing if you were buying insurance for hurricane insurance and you live in a hurricane area and a massive storm strikes and knocks out so many creates great hardship in the area, and a small insurer may go bankrupt trying to cover that, but they have reinsurers as well, so they work with a bigger insurance kind of Lloyd's of London or some big entity that can actually back something the size of a massive storm. So laws, I think, like that too, waterfalls a little bit in terms of the risk, and so you've got folks out there willing to take some risk, or depending how you see it, not take the risk to make sure you are covered off, and to they know that they're using tools like freedom to operate IP tools that are using it appropriately so that they can take that risk.
Yeah. So I would add a little bit to that. I know in BC, every BC lawyer with the Law Society of British Columbia, they're insured because the Law Society requires it. The insurance amounts, though, are not great. So
Hmm.
depending on what the financial risk is that you have based on relying on legal advice that's incorrect, you have to look at the actual insurance amounts. Now, in many of the US states, there is no insurance for lawyers as a required mandatory thing.
Hmm.
So, in many of the states in the US, if you go to a small solo practice or a small firm, often they won't have insurance. And you have to sue the lawyer for malpractice, win the lawsuit, and then you have to chase them for the money if you get a judgment. That's why big brand name law firms are preferred in many cases in the US because they will have insurance. And having malpractice insurance is an important aspect of risk management because you get your lawyer's advice, but then you, as the founder, advisor, or investor, you make the business decision. And then if that decision goes wrong, it costs you a lot of money, and you can say it's because of that bad legal advice, that's where you might have a malpractice claim. But that is, again, a lawsuit. So that's work. It's more money, it's more effort. You want to avoid that altogether if you can. And so that kind of addresses Sajad's questions because he's also asking not just about insurance, but also, what happens if you create a draft and the lawyer reviews and approves it? Are they going to be responsible and does that reduce costs? So we've addressed that question as well. We're going to go on to Marco's question. Marco says, does it make sense to have a lawyer review AI generated work, or does it take longer to actually retrofit a document that a lawyer is not familiar with? I think we've touched on this as well.
Uh, yes, it's certainly all a function of time. I mean, traditionally lawyers bill on time, and that's by the hour. And so now I think that is something we're seeing changing. AI can enable that to change. So the work that we do through legal now is largely on a fixed fee basis. So you come in, we do a great job of scoping it, so the lawyer knows exactly what they can do. The reason the bill for the billable hours, because oftentimes in the past lawyers didn't know how big it was going to be. It was going to seem small at the start, then it grows big. But if you have good scoping tools and AI to really elicit, and for that matter, AI to help clients coming and training themselves a bit or getting up the curve on these issues coming in, then it's very clear what the cost is going to be. So it's sort of case by case, I guess, is the answer, and lawyer by lawyer. But if you're working with us, it's helpful to kind of get as much information out before we get you to the lawyer, and then they are able to kind of quote fixed fee, and then the client can make the decision as to whether or not they want to move ahead with that. So. I'm just
Okay.
mindful of the time here, Cheng.
Yes, we are running down the clock. We're going to go down to one last question,
Okay.
and then we're going to close it off. For the last question, it's from Cykel, one of our startups in town. Cykel asks that for many lawyers, they ask for a retainer, which can be financially inaccessible for the startup and for the scaling organization. If you want to use Legal Now to create legal documents and then have lawyers to validate that document, does the retainer still work, and how does that work for their budget?
Right. So our ideal method is to work fairly closely with the lawyer. And, like, to be frank about it, it's still a new concept, what we are doing. So it takes a bit of explaining for lawyers to work with us. And our model is to do it on this sort of fixed fee basis and paying through credit card and avoiding the thing that's challenging for small firms is what they call trust accounting. They take a retainer from the client, they need to sort of manage very, very closely and report to the Law Society a lot of accounting rules around that. If we take that out of the equation, it's just simpler. The lawyer knows that if the client's coming through us and everything's agreed, that we've taken the funds from the client for the very discrete project-based work, and then they can get paid that way. So we partner closely with firms. If a client has their own law firm they're accustomed to working with, we can absolutely have a conversation to see if there's a way to work together. But if for some reason they chose not to use this new approach, as we've alluded, there certainly are different approaches to AI that lawyers are using. Some don't want to use it, I suppose. Then there's a case where we can do some things, some prep work with a client. We do some, even prompt writing types of work. So we can produce things that a client can go, it's a structured, well-designed prompt. They can go and create it's a term sheet between, say, co-founders or a business partner, and then take that to the lawyer. So that saves some time, even at the upfront. But it's case by case, kind of working with us as to, we have a sense for when the situation is one where we can really add value and one where it's will provide value around the edges as opposed to kind of overseeing the process end to end. And so I'd love to end on just this kind of quick five top tips for folks. And feel free to kind of screenshot this if you like, everyone. We'll send a follow-up email with, on the one hand, the recording and also these tips in that email as well. Really quickly run them down, and then you can stay a little longer if you like, Chang. Some folks may be dropping off, but I just want to make sure we got this kind of out, my sort of boil it down, key things to think about.
Are you going to
So
be offering our attendees a discount for legal now?
Yeah, case by case, I would say we're really here to understand clients' budget, right? With the whole much the job of this, as I've alluded to, is kind of this risk spectrum. We understand where a startup is at and know that frame really well because I've been there myself multiple times and designed this tool for what I would have wanted along the way, as opposed to kind of throwing in the kitchen sink. And some firms, just over lawyer the thing. We don't do that. We size it down to what you have to spend. So that's one of the reasons really to work with us. But I'll say if you're using AI to some extent, largely on your own to get going at least before you've raised that seed round or whatnot, where you can really get the lawyers in properly doing things. I would say top tips. So have the AI tell you about the most important things. So try and focus it a bit on like what are the key legal issues of a project, the key risks. I would say number two, it'll help you get organized before seeing a lawyer, so they don't bill you for helping organize you. So again, eliciting some of those legal risks, asking it to say, well, hey, if you were a lawyer, how would you interview me for this situation? Like, what kinds of information do I need going in? What should I be thinking about going in? Number three, create kind of low risk cog in the wheel documents, but no, they won't address every risk. So we talked about that with the NDAs. Just something that facilitates the conversation. It's going to cover most things, maybe 80, 90% of risks. Understand though, in the more, we alluded to these as well, the high risk areas of like really in-depth sort of patent licensing rules. Like an NDA is not going to, just off the shelf or like GPT one-shot NDA is not going to cover it. So I would say number four, interpret legal documents presented to you and prioritize issues. So that's great when you got something inbound, trying to figure out, well, there's a bunch of legalese in this document from the lawyer on the other side. What does it mean? What do I care about in this? It just helps you get confident, again, either in replying or ideally confident before going to a lawyer and saying, this is what I think the direction we should go with this, and let them weigh in to say if that sounds on point or not. And then finally, I would just say, understand your business deeply so your LLM can fill in your lawyer. So using AI, I think many more and more founders we're working with have an AI that understands actually their whole business end to end. They're using it for every question, and more just embedding data through that. So it's just this like data layer that lives with the AI. And so from that, all sorts of questions can be drawn out using AI, either through our system or sort of briefing your lawyer, asking your AI adept to kind of really come out with all the legal issues that matter. Again, if it's an AI first law firm, they're going to be well suited to kind of ingesting that, trying to make sense of it. But AI is just really powerful at translating things that happen in business, if it can see them and understand them, into things to think about, or at least that lawyers can assess and then bring their legal expertise to the table. So it's just an interesting trend we're seeing of AI being really a partner in business creation and growth.
Amazing.
Yeah.
Well, thank you so much, Steve. It was fun to have this conversation. We are just a few minutes over time. So I want to thank the patience of all those who are still with us. I know this can be really interesting for some people. It can be fundamental for their business for others. And I hope this might be the beginning of a series of conversations to dig deeper in some of these topics. It's obviously very prime for what's happening for many of our startups today.
Yeah, I would love to do that. In fact, we're talking with Circle Innovation about creating more extensive programming. So if this is of interest to you folks, if you find this conversation helpful, let us know, please. Feel free to email me here and just jump in and use the platform. It's really designed for users to just start using AI right out of the box on our website, and so you can get answers from the chatbot, and also risk assessment to figure out, are you in the green zone, yellow zone, or red zone? Red zone meaning you really need a lawyer, and we can make that happen. Yellow zone, arguably, we've got whole workflows and structures where you can get in and get that need met. So yeah, just jump in and try it out, and would love to hear from you. And always fun to jam with founders on understanding their journey and the road. Always challenging road of the early days, an exciting road that folks are walking because I've been there a few times myself. So Chang, thank you very much for attending this and really bringing your expertise because evidently you know the space, and some great questions and great moderating. So thank you.
Absolutely. And with that, we're signing off. We're at the end of our coffee.
Yeah, good stuff. Thanks, Chang. Thanks
Bye,
all. See you
everybody.
later.